Look, it's a topic nobody really loves to talk about, but thinking about your final footprint, it's genuinely one of the most important things you can do for the people you care about. So where do you even begin? Let's break it all down and make it simple.
It really all boils down to this one single question. When you're gone, what happens to all your stuff? Who gets to decide? And the answer is pretty straightforward. Either you do or the government does. That's it. There's no in between.
So think of it like this. Your estate is about to go on a journey, and there are two possible paths. Path A is your plan. It's a clear, well-marked road that you designed yourself with a will. But Path B, well, that's the state's plan. It's a tangled, confusing maze that just kind of appears when you don't have a map of your own. Let's start by taking a peek inside that maze.
So, what actually happens when you leave no map behind for your loved ones to follow? Well, you enter a legal state that comes with some very real and often really unintended consequences.
And there's an official word for this situation. It's in state. It's just a legal term that means you've passed away without a valid will. It's a super important word to know because the moment it applies to you, a whole different set of rules kicks in.
And the consequences of being intestate, of being in that maze, they can be huge. The court suddenly steps in and starts making all the big decisions. They'll pick the person who manages your entire estate. And if you have minor kids, they could appoint a guardian you never would have chosen. As for your assets, they get divided up based on a rigid government formula, not what you wanted. The whole thing can drag on, get expensive, and, get this, could mean a separated spouse inherits while a long-term common law partner gets nothing. It can get messy.
Okay, so that's the scary part. But the good news is there's an incredibly powerful tool you can use to avoid that maze completely. This is how you create your own map and take back control of your estate's journey. Let's talk about the will.
So what is a will, exactly? At its heart, it's your personal map. It's a legal document that lays out in no uncertain terms exactly how your property should be handled after you're gone. It's the instruction manual that ensures your final wishes are actually followed. Now, you might think a will is a will, but it's not quite that simple. There are actually a few main types. You've got the formal will, which is probably what you picture, typed up, signs with witnesses. Then there are special regional ones like the notarial will in Quebec. And then there's the holograph will, which is written completely by hand, but it isn't even recognized everywhere. The big takeaway here, what actually counts as a legal will really depends on where you live.
You know, every will has its own cast of characters. You, of course, are the testator, the person making the will. The personal representative is the person you trust to carry out your plan. Your beneficiaries are the people who inherit your assets. And if you have kids, the guardian is the incredibly important person you name to care for them. Every single role is vital to making the whole thing work.
All right, let's zoom in on one of those key players, the guide you entrust with your map. Your personal representative has one of the absolute most important jobs in this entire process.
And it is not a small ask. This quote really says it all. The role can be arduous and time-consuming. This isn't just some honorary title you hand out. It's a serious job with a lot of real work involved.
Their huge job really breaks down into 4 core duties. First up, they have to find the will and then secure and inventory everything you own, down to the last dollar. Then, they have to navigate the entire legal process, getting probate, notifying banks, filing claims. After that, they have to settle all your debts and file your final tax returns. And only then, after all of that is done, can they finally distribute what's left to your beneficiaries. It's a marathon, not a sprint.
So who on earth do you pick for this massive role? Well, it's not just about who you trust the most. You need someone who is reliable and actually available to do the work. But just as crucial, they have to be willing to do it. And that last point, being objective and impartial, man, if your family dynamics are a little complicated, that quality can be an absolute game changer. So I've mentioned that word probate a couple of times, and I know it can sound pretty intimidating. It's one of those legal words that sounds way scarier than it actually is. So let's just pull back the curtain. What is probate anyway? Simply put, probate is just the court's official stamp of approval. It's the formal process that confirms 2 things. 1, yep, this will is the real deal, it's valid. And 2, yep, the personal representative you picked has the legal authority to actually follow your instructions. That's all it is. Now, here's where things get really interesting. Not everything you own actually has to go through probate. See, assets that are in your name alone, yep, they're part of the probate process. But things you own jointly with someone else, or assets that have a specific person named as a beneficiary, well, those can often bypass the whole process entirely.
For example, stuff like life insurance policies or registered plans like RSSPs and TFSAs, if you've named a beneficiary on them, the money goes directly to that person. No probate needed. Same thing with property you own as joint tenants. These assets get to take a special shortcut, a more direct path to your loved ones, saving a lot of time and hassle.
Okay, so you've done it. You've created your map, you're all done, right? Well, not quite. A will isn't a set it and forget it kind of thing. You have to think of it more like a living document, one that needs to grow and change right along with your life. So when should you dust it off for review? Think of any major life event as a big red flag. Getting married can actually cancel your old will in some places. Having a baby means you need to name a guardian. Separating or getting divorced, starting a business, a big inheritance, all of these are signs that it's time to pull out the map and make sure it's still pointing everyone in the right direction. And this is the real bottom line here. An outdated will can cause just as much chaos and confusion as having no will at all. It might lead to a result that is completely the opposite of what you'd want today.
Which brings us right back to where we started, to that choice between a clear path and a tangled maze. So, the real question to ask yourself is this: is the map you've made clear enough for your loved ones to follow, or, when the time comes, will it end up leading them right back into that maze?